In the criminal justice system, the people are represented by two separate yet equally important groups: the police who investigate crime and the district attorneys who prosecute the offender.
Hi, Detective Olivia Benson here. On this episode of Law & Order, I'm going to review 5 of my favorite cases. First one is Illinois v. Cabayas, Indianapolis v. Edmond, Illinois v. Lidster, Rhode Island v. Innis, and Michigan v. Sitz. Before I present these cases, let me tell you about the 3 basic amendments that all of these cases are based off of. The first is the Fourth Amendment, which protects people from unreasonable searches and seizures. Related to the Fourth Amendment is the exclusionary rule, which prevents the government from using evidence illegally detained from a search. Next is the Fifth Amendment, which protects a person against being compelled to be a witness against him or herself in a criminal case. Pleading the Fifth is a colloquial term for invoking the privilege that allows a witness to decline to answer incriminating questions. Last is the Sixth Amendment, which guarantees a citizen a speedy trial, a fair jury, an attorney if the accused person wants one, and the chance to confront the witnesses who is accusing the defendant of a crime, meaning he or she can see who is making accusations. The first case we're going to cover is Illinois v. Cabayas. This case is based on the Fourth Amendment. In this case, during a routine traffic stop, a drug detection dog alerted police to marijuana in Roy Cabayas' car trunk. An Illinois court convicted Cabayas of cannabis trafficking. Cabayas appealed and argued the search violated his Fourth Amendment right to be free from unreasonable searches and seizures. In the end, the court ruled that the police performed the canine sniff without specific and articulable facts to support its use, unjustifiably enlarging the scope of a routine traffic stop into a drug investigation. Now, in order for you to better understand the case, my crew will reenact it for you. Here, you will see Olivia running a stop sign, while Hannah, the police, in her gray Jeep, will pull Olivia over. Now, Officer Hannah will call Officer Marquez to bring her drug-sniffing dog.
Pulled someone over for rolling a stop sign and things like this. Okay, I'm coming with the canine right now.
Here is our trusty canine trooper.
Do you know why I pulled you over today, miss?
No.
Olivia demonstrated the perfect Hinsdale roll.
It's because you rolled that stop sign back there.
Okay, I'm sorry.
Hannah now asks Olivia to step out of her car.
Would you mind stepping out of your car?
Why?
Because I need to search your car for illegal things.
Why?
Because I need to.
Olivia is quite bothered and gets out of a very dirty car. Hannah then informs her of the search that will be done on her car.
My partner with her canine is gonna come search your car now.
After waiting 30 minutes for Officer Marquez to come, she finally does. Do you think this is okay to prolong a traffic stop like this?
Officer Marquez?
We're gonna search the car now.
As Officer Marquez and Trooper search the car, Trooper sniffs the trunk and finds something in there. It happens to be drugs. Do you believe a dog is a sense-enhancing or sense-creating device? After the dog finds drugs in the back of her car. She is then put into custody. Now, Judge Harper will present the holding.
Police may not conduct roadblocks whose primary purpose is to detect evidence of ordinary criminal wrongdoing. Such roadblocks must have a specific primary purpose, such as keeping roadways safe from impaired drivers or enforcing border security.
Now the question is, does the Fourth Amendment search and seizure clause require a reasonable articulable suspicion to conduct a canine sniff during a routine traffic stop? The conclusion of Illinois v. Cabayas was that the Constitution did not require police to have reasonable suspicion to use a drug detection dog on a car during a legal traffic stop. The drug sniffing dogs are legal, but the police cannot prolong a traffic stop just to get the dog. Another one of my favorite cases is Indianapolis v. Edmond. This is a Fourth Amendment case. The facts of this case are that the city of Indianapolis instituted a series of traffic checkpoints. At each checkpoint location, the police stopped a predetermined number of vehicles. An officer approached the vehicle, advised the driver to produce a license and registration, and watched for signs of impairment and conducts an open view examination of the vehicle. They could only do so with consent. A narcotics officer walked around the car with the dog. The whole stop was to only be 2 or 3. Now, in order for you to better understand the case, my crew will reenact it for you.
What is this? Oh my gosh!
Here, Officer Marquez has created a roadblock where Olivia must stop.
What am I gonna do?
Officer Marquez marches to Olivia's car and bangs on her window.
Excuse me, miss, you were texting and driving?
I wasn't, I promise, I swear.
Officer Marquez then asks Olivia to step out of her vehicle.
Ma'am, I'm gonna have to ask you to step out of your vehicle so I can search your car.
Here, Olivia gives the officer a few wise words.
According to Mr. Hipskin's class, sir, this is against my Fourth Amendment right.
I'm still gonna need to have you step out of the vehicle so I can search your car.
Olivia once again gets angrily out of the car, obeying the officer's request. Officer Marquez searches the car herself and then directs the drug sniffing dog to search the car as well. Trooper is at it again. This time, no drugs are found and Olivia is set free.
Order in the court.
Ananda has the holding.
The Fourth Amendment does not forbid the use of a checkpoint to investigate traffic incidents.
The question is, are highway checkpoint programs whose primary purpose is discovery and interdiction of illegal narcotics consistent with the Fourth Amendment? In the end, the court reaffirmed that a vehicle stop at a highway checkpoint effectuates a seizure within the meaning of the Fourth Amendment, and also said that it never approved a checkpoint program whose primary purpose was to detect evidence of ordinary criminal wrongdoing. Without drawing the line at roadblocks designed primarily to serve the general interest in crime control, the Fourth Amendment would do little to prevent intrusions from becoming a routine part of the American life. The next case I'll show you is Illinois v. Lidster. This is also a Fourth Amendment case. In this case, in response to the hit-and-run death of a bicyclist, police set up a checkpoint to ask occupants if they had any information about the incident and handed each driver a flyer about the matter. Respondent Robert Lidster's vehicle swerved as it approached the checkpoint. A roadside sobriety test determined that the respondent was driving under the influence of alcohol. Now, we will reenact this for you. Here is Officer Marquez's police car. Hannah is driving and nearly hits Officer Marquez at the checkpoint. Suspected to be drunk, Officer Marquez asks her this.
Step out of the car. Please walk in a straight line. Stay on the line.
Hannah is obviously struggling and fails the sobriety test at the checkpoint.
Can you balance on one foot?
Hannah is no longer allowed to drive any farther, and Officer Marquez takes her into custody.
The Fourth
Ananda once again has the holding.
The Fourth Amendment does not forbid the use of a checkpoint to investigate a traffic incident.
Reflecting back to a previous case, does Indianapolis v. Edmond, which dealt with the Fourth and 14th Amendment prohibition of unreasonable searches and seizures, prohibit checkpoints organized to question motorists about a previous offense and arrest motorists for drunk driving? So, in conclusion, the court distinguished this case from Edmond, noting that in this matter the checkpoint was not determined whether a vehicle's occupants were committing a crime, but to ask the vehicle's occupants for their help in providing information about a crime committed by others. They did not believe that an Edmond-type rule is needed to prevent an unreasonable proliferation of police checkpoints. The stops intervened only minimally with liberty. The next case that we'll demonstrate is Rhode Island v. Innis. This is both a Fifth and Sixth Amendment case. In this case, after picture identification by the victim of a robbery, Thomas J. Innis was arrested by police in Providence, Rhode Island. Innis was unarmed when arrested. Innis was advised of his Miranda rights and subsequently requested to speak with a lawyer. While escorting Innis to the station in a police car, 3 officers began discussing the shotgun involved in the robbery. One of the officers commented that there was a school for handicapped children in the area and that if one of the students found the weapon, he might injure himself. Innis then interrupted and told the officers to turn the car around so he could show them where the gun was located. Now, my crew will demonstrate their own version of this case. Here's Hannah in the back of the cop car after being caught drinking under the influence. She has read her Miranda rights. Wow, love that sweatshirt. On the way to the station, Officer Marquez and Officer Harper discussed this.
Did you hear about that guy that was robbed at gunpoint?
The man holding the gun just happened to be Hannah.
Yeah, they said the money that was in his wallet he was going to use to pay for his wife's cancer treatment. Oh.
Hannah hears this while in the back of the car and admits her crime.
Okay, it was me. I was the one who robbed that man at gunpoint. I feel so bad.
She is taken out of the car to then be reread her Miranda rights.
You have the right to remain silent. You have the right to an attorney. Anything you say will be held against you. And if you can't afford an attorney, we will get you one.
Well said, Officer Marquez.
Order to the court.
Officer Harper with the holding.
The court then found that the officer's conversation did not qualify as words or actions that they should have known were reasonably likely to elicit such a response from the criminal.
The question is, did the police interrogation en route to the station violate Innis's Miranda rights? The court concluded that the conversation was not an interrogation and therefore the respondent's rights under the Fifth Amendment of the U.S. Constitution were not violated. Interrogation should not be so broadly defined to include such a wide range of conduct by officers post-arrest, but rather should only include conduct that police should know would inflict a response. Finally, the last case we'll review is Michigan v. Sitz. This is a Fourth Amendment case. In this case, in 1986, the Michigan State Police Department created a sobriety checkpoint program aimed at reducing drunk driving within the state. The program included guidelines governing the location of roadblocks and the amount of publicity to be given to the operation. Before the first roadblock went into effect, Rick Sitz, a licensed Michigan driver, challenged the checkpoints and sought declaratory and injunctive relief. Sitz was victorious in the Michigan lower courts. Now, my crew will act out the last of our demonstrations. Officer Marquez has once again created a routine traffic stop, where Hannah will be asked to stop. Officer Marquez asks her to step out of the car.
Please step out of the car.
Yes.
Hannah will now pass the sobriety test with flying colors.
Can I have you walk on the straight line? Can you stand on one foot? Now switch to the other foot.
Hannah is free to leave, but is outraged that she had to perform this test, even though she was completely sober.
Okay, you're fine. You can go. Okay.
She nearly clips the front of Officer Marquez's cop car. Judge Harper with the final holding.
No one can seriously dispute the magnitude of the drunken driving problem or the state's interest in eradicating it. And the weight bearing on the other scale, the measure of the intrusion on motorists stopped briefly at sobriety checkpoints is slight.
The question is, did the drunk driving checkpoints violate motorists' privacy protected by the Fourth Amendment? In conclusion, the Supreme Court held that Michigan had a substantial government interest to advance in stopping drunk driving and that this technique was rationally related to achieving that goal. The court also held that impact on drivers, such as delaying them from reaching their destination, was negligible, and that the brief questioning to gain reasonable suspicion similarly had a negligible impact on drivers' Fourth Amendment right from unreasonable search. Pop quiz! Number 1. True or false? The Fourth Amendment gives the accused the right to a speedy and public trial. False. That's the Sixth Amendment. Number 2. True or false? Drug sniffing dogs are sense-creating devices. False again. They are considered sense-enhancing devices. Number 3. Yes or no? Are highway checkpoint programs whose primary purpose is the discovery and interdiction of illegal narcotics constitutional? No. They cannot sanction stops justified only by the generalized and ever-present possibility that interrogation and inspection may reveal that any given motorist has committed some crime. Number 4. Yes or no? Are highway checkpoints where police stop motorists to ask them for information about a criminal matter complied with the Fourth Amendment constitutional? Yes. The safety of the public is a priority, and the time taken to conduct one of these is minimal. In Rhode Island v. Innis, is the conversation between the officers in front of the respondent constituted an interrogation as defined in Miranda v. Arizona, the case which created the Miranda rights? No. It was not an interrogation because the police officers did not know that their conversation would elicit a response. Number 6. Yes or no? Does the state's use of highway sobriety checkpoints violate the 4th and 14th Amendment to the United States Constitution? No, because it prevented drunk driving accidents and the time taken was minimal. Last one. Number 7. True or false? Mr. Hipskin is the best teacher ever and con law is the best class to take in Hinsdale Central. True? Is that even a question? Things that we learned from this episode. Always keep your dog in the back of your car. Make sure your car is clean before videoing. Don't keep bags of flour in your trunk. This episode was low budget.
Okay.
That sobriety tests are harder than they look.
Now switch me.
Okay, it was me. I
To
was
not
the
keep
one who robbed
secrets.
that man at gunpoint. I feel so bad.
And to drive safely when around police.
You know what?
You guys suck.
You know why I pulled you over today, miss? No. Oh, you rolled this off. You know why I pulled you over? You know why? I was good. My partner was moving with my Officer Marquez. Officer Marquez. Cooper and I are gonna search
Madison! Perfect!
Because he was sniffing the back.
You're more violent. You're angry.
The Fourth Amendment does not forbid the use of a checkpoint to investigate a traffic incident. I'm sorry.
That was so good.
I know.
Yes.
Why do you keep looking at her? Are you supposed to look
Yeah,
at
it's
her?
kind of like a look at
Okay. I'm gonna look back and forth.
say like
Okay. Why are you so... There was no noise! No one can seriously dispute that they were recording. Okay.